Hi, this is Kowski, and in this video we're going to be doing a last-minute review for the AP Gov exam. By no means is this considered to be a detailed video, but a quick overview. If you have not been paying attention in your AP Gov class or you just need a quick review, this is the video for you, as we're going to be going through this in rapid speed. So let's start with Unit 1. And if you recall, the origins of the Constitution start with the Articles of Confederation. If you recall, we were very, very weak, had no power of the presidency, you had no judicial courts, and really most of the power went to the states. And this becomes a problem as evident in Shays' Rebellion, and this is going to lead to the abolishment of the Articles of Confederation and lead to the U.S. Constitution, which is going to be drafted and using many of the ideas from Locke and the Enlightenment. And from this Constitution, we're going to see many compromises included, from the Great Compromise, the Three-Fifths Compromise, the Electoral College. These are all compromises that are going to be made amongst the representatives during the Constitutional Convention. And again, very, very important, you're fixing the weaknesses of the Articles and creating the new and improved Constitution, which we have today. Now, before it gets ratified, there was a lot of debate about whether or not the Constitution should be even a thing. We've drafted it, but now we need it to be ratified. And we, of course, have the Federalist Papers, which are going to come out and advocate for the ratification. And Federalist 10 is going to say, hey, we are going to be creating this pluralistic type of document where, these groups are going to be working equally and countering ambition with ambition, as advocated in Federalist 10. In Federalist 51, it's going to say, hey, we're going to have checks and balances, we're going to have separation of powers. And in Federalist 70, it's going to advocate now for a single executive with great energy who can respond rapidly to instances as opposed to the council. In Federalist 78, that, of course, dealing with the judiciary, they're going to say, well, now you're going to have this institution that's going to protect the people. And even though these people are going to be elected or appointed and served for life, keep in mind they have no implementation power, as they will have no power of the purse nor the sword. Now, the one document that you are required to know that it's sort of anti-federalist and anti-ratification is Brutus I, which is going to say, you know what, this federal stuff, Federalist paper is more nonsense. We need a smaller republic. We should be focusing on states' rights. There's too much power given in this document, such as the Supremacy Clause and the Elastic Clause. Too much power given to the national government. We need to make sure that the power of the states is very much, strong and maintained as it was under the Articles of Confederation. Very important that you know these documents, as they are required for the AP Gov exam. And of course, this is going to lead to ratification, but only because of the Bill of Rights, which is going to be required by the Anti-Federalists for ratification. And upon ratification, we have now the Constitution that we have today. And in our Constitution, we have this concept known as federalism, which is the relationship between the states and the national government. Up until the 1930s, up until when we hit FDR's presidency, you have dual federalism, where the states and the national government were doing their own thing. There was no overlap. After FDR and the Great Depression, we have this new concept known as cooperative federalism, where we have much more overlap. The states and the national government are working together, and we see this through various grant systems. We have block grants, which money is going from the federal to the state governments. You have categorical grants that come with strings attached with the money, but that is in our nature of federalism, and that is one of the good examples that we have with it today, along with the Electoral College and many other instances. Now, we certainly have a very strong national government. This has increased over time thanks to the Elastic Clause, the Supremacy Clauses, and don't also forget about the Commerce Clause. But one of the earliest cases that's going to establish the strength of the national government is going to be McCulloch v. Maryland, which is going to be when Maryland tries to tax the National Bank, and the National Bank is going to fight back in McCulloch v. Maryland, and it's going to basically say, thanks to the Supremacy Clause as well as the Elastic Clause, this is going to be needed, and this is going to substantially increase the amount of power the national government has over the states. Now, it's going to be tied in this way up until about 1995 with U.S. v. Lopez, when the United States government is trying to regulate gun-free school zones using the Commerce Clause. And the national government is, again, going to argue that they have that right under the Commerce Clause, but the Supreme Court is going to strike that down and decrease some of that power. It's going to put the government sort of in its place, and this is a win to some extent for state governments. But again, this is an ongoing debate as to what the strength of the national government should be. All right, now moving on to Unit 2, which is the meatiest of the units. Here are the various differences between the two chambers of Congress. You'll certainly see that the House is much bigger. They serve shorter terms. They are much more responsive to the people compared to the Senate, as they are elected every 2 years as opposed to every other 6 years. You'll see that there's very strict rules, limited debate, very, very formal, whereas the Senate tends to be a little bit more flexible. They have fewer members, so it tends to be a little bit more cordial, not as rigid, because you're not controlling 435 people, but certainly very important roles in approving and rejecting treaties, as well as confirming presidential appointments. Now, in Article 1, Section 8 is where we find all the delegated or enumerated powers of Congress. Everything from taxation to the creation of military to even declare war. Those are powers of Congress. These are the formal powers of Congress that they have. And you'll see even with impeachment, the House brings the charges and the Senate tries the case. And then there are also exclusive powers, which are powers given just to one particular chamber of the Congress. And of course, with the House, they have all power when it comes to revenue bills and impeachment. And in addition, we see this with the Ways and Means Committee and Rules Committee. Those are both unique to the House of Representatives. It's also important to note that you have a Speaker of the House, as opposed to the Senate, where you have Senate Majority Leader. And in the Senate, they are unique in their role with Foreign Relations and Judiciary. If you serve on either of these committees, it's important to note that you are a much more prestigious member, because remember, they have confirmation power in judicial appointments, as well as ratifying treaties, etc. Keep in mind that when the House and the Senate pass a bill and they have to reconcile it, this happens in your conference committees. All right, dealing with the legislature, specifically with the House of Representatives, and drawing up the maps, gerrymandering, those odd-shaped member districts that are set by the states. And the first instance of this is where it's going to be challenged in the courts is Baker v. Carr, which is going to establish the one man, one vote, basically saying certain districts can't have less people or more people than others. They have to be relatively equal. And this is going to open up the door for courts to rule on this matter. And this is later going to be affected in a case known as Shaw v. Reno, where the districts are going to be carved in a way that favors and basically lumps together black voters, creating what's called a majority-minority, where you have a majority of the minority in that state pushed into a district. And they're saying that's going to be a violation of the 14th Amendment, and it's unconstitutional. And certainly that's going to be a little bit of a blow to gerrymandering. But as of the making of this video, gerrymandering is still constitutional, other than when it's based on race. All right, dealing with presidential powers, a lot of informal powers you'll see here. But some of the formal powers, in particular, Commander-in-Chief, right? These are coming straight out of Article 2 of our Constitution, appointing ambassadors, State of the Union, right? These are very, very important. Whereas with the informal, right, the president has executive orders, the president has executive agreements, the president is going to utilize the bully pulpit, so it's very important to know the differences between the formal and informal powers. And then with the judiciary, once they are appointed, right, they serve for life. You have judicial review, which is going to be established by Marbury v. Madison, and that is humongous in terms of really giving the government its, in particular the Supreme Court, its muscles to be equal amongst the other two branches. And then you have judicial restraint, where the justices are going to avoid making policy out of their decisions. They're going to rule within the scope of the law, whereas activism is going to be going on beyond the law and creating some type of policy. Remember, the courts were not designed to create policy, but an activist judge would certainly think that they would be entitled to do so. Very important to know the checks and balances between the three branches. What can they do to each other? Very, very important. In many ways, this is a separation of powers, checks and balances type of test. So definitely know this graph in more ways than one. And then we have the bureaucracy. And that, in many ways, is considered the fourth branch, although it does fall technically under the executive branch. And we have cabinets, right? They are the advisors to the president. Then you have independent executive agencies, such as NASA, right? They don't fall in any one of these other categories, so they become independent executive agencies. But if you are regulating, enforcing, creating laws in terms of rules over a specific area, such as the FCC with respect to communications, whether it's the airwaves of the television signals or radio signals, that's falling under the Independent Regulatory Commission. And they cannot be fired for political purposes. They are appointed by the president, confirmed by Congress. And then you have government corporations. These are corporations that are making money. So USPS, Postal Service, is making money. For example, you purchase a stamp. That is going to the government. It is a government-run corporation. They are making money. Be familiar with these types as well. Now, there are checks on the bureaucracy, for example, from Congress. If they don't like it, they can just simply defund it. They can abolish it. They can even impeach the executive officials that run it if there is misconduct there. With respect to the courts, certainly they're going to exercise judicial review if there is a rule that they make is unconstitutional. And then even with the president can, shake up an agency. The president has the power of appointment, so that's one way that the president can certainly impact the nature of the bureaucratic agency very much, especially too with the executive orders in terms of how a particular agency should carry out the law. All right, moving into Unit 3. And Unit 3 is all about the Bill of Rights and selective incorporation. Remember, the Bill of Rights only applies to the national government, so each aspect or amendment of the Bill of Rights has to be incorporated to all 50 states one by one, and that comes through Supreme Court cases. And with respect to a lot of these civil liberties and rights, if we're dealing with a civil liberty, meaning any one of the amendments that is dealing with civil liberties, we're dealing with the Due Process Clause section of the 14th Amendment, or if we're dealing with the civil rights matter, we're dealing with the Equal Protection Clause. So some of the important First Amendment cases to know is Engel v. Vitale, saying school sponsorship of religious activities is a violation of the Establishment Clause, too close with government and church. With Wisconsin v. Yoder, this is dealing with the Free Exercise Clause. Basically, the government is going to be restricted from impeding on someone's exercise of their religion because Amish students are compelled to go to school beyond 8th grade, which is a violation of their religious tenets. In Tinker v. Des Moines, students have the right to free speech as long as it does not distract from their education. In this case, wearing armbands to protest the Vietnam War. So this is a major win for students in symbolic speech. And then you have Schenck v. U.S., which is going to establish the clear and present danger test, which can limit speech and impose prior restraint. So in this case, encouraging people not to join the draft, and again, keep in mind this is right during World War I, it was considered a danger to national security, and thus your free speech right can be restricted. In New York Times v. U.S., certainly the opposite end here, it's going to be bolstering the freedom of the press, even in cases involving national security. If you recall, this deals with the Pentagon Papers, and prior restraint is very, very difficult to limit. And again, prior restraint, talking about censorship. All right, other cases. McDonald v. Chicago, Second Amendment is going to be incorporated here. The right to bear arms and not restricting handguns in this case is going to be a more recent case that you're going to need to know. Miranda v. Arizona, certainly you are going to be told that you have the right to a lawyer and remain silent, so you're going to be informed that you do have these rights and that you do not need to talk to a police officer or anybody should you choose not to. And then Gideon v. Wainwright is going to establish the right to a public defender. Prior to this point, you would basically represent your own self if you could not afford a lawyer, and that is a very big extension of the Sixth Amendment. All right, dealing with the Fourth Amendment, there's not any particular case that you need to know, but keep in mind in the digital age of being protected, that's very important, and the courts have been relatively sympathetic towards extending protections of the Fourth Amendment in this digital age. Keep in mind, too, if the police come into your house without a warrant, and you don't let them in, it is subject to the exclusionary rule as well, so that's another aspect of the Fourth Amendment you should be aware of. And then with the Eighth Amendment, no particular case either specified by the AP Gov people, but you cannot execute juveniles, physically ill, mentally ill, they cannot receive the death penalty. Now, other cases I would be very familiar with, Roe v. Wade is required. This is going to extend the use of privacy to an abortion, and that's going to be found under multiple amendments from the 14th, the 9th, the 4th, and even the 3rd. So this is going to be major and very controversial decision. And again, still ideologically, this court case is very much debated. And then in Brown v. Board of Education is going to argue, again, under 14th Amendment, that racial segregation is in schools is unconstitutional under the Equal Protection Clause. It is important to note this other information, other pieces of information you need to know, and that includes the civil rights and what that means, right? We're talking about making access, equal access to all civil liberties. Whereas the Civil Rights Act of 1964, it's going to be banning public discrimination in public places such as hotels, eateries, and all that good stuff. Voting Rights Act of 1965, that's going to make it easier to vote, limiting obstacles such as literacy tests. You'll also recall that the 24th Amendment is going to outlaw the poll tax. That, of course, is separate from the Voting Rights Act, but I figured I'd mention that. And then the letter from a Birmingham jail that's going to be espousing civil disobedience by Martin Luther King Jr., and it's really going to be advocating for direct confrontation in a more nonviolent, peaceful manner. And then Title IX, equal funding for women in schools and sports. This is huge, especially at the college level. So if you have to have sort of equal funding. So if the boys team gets a new turf field, well then the girls team should also get one, or at least have the same amount of access to that field. All right, we're going to stop there on Unit 4, go over to Part 2 in our final review.